Supreme Court dismissed the appeal in the matter of JAMIN versus State of Uttar Pradesh, and trial court was directed to take necessary steps in furtherance of summoning order dated 21 February 2024 to ensure that appellants are produced before court to face the trial. In this case, Supreme Court considered the following issues: whether High Court was right in exercising its revisional jurisdiction for purpose of setting aside order of trial court rejecting second application preferred by respondent number 2 under section 319 of CRPC, whether order dated 21 February 2024 passed by trial court to give effect to order passed by High Court directing it to reconsider the application under section 319 of CRPC would relate back and replace its earlier order dated 19/7/2010 rejecting the section 319 application, whether the trial court could have entertained an application filed under section 319 of CRPC after conclusion of the trial, more particularly when no stay on trial had been granted by High Court, whether the High Court should have given an opportunity of hearing to proposed accused before deciding revision petition filed against rejection of application under section 319 of CRPC by trial court. If yes, whether the order dated 14 September 2021 passed by High Court in exercise of revisional jurisdiction was passed without notice to appellants and providing them an opportunity of hearing. Court said that Section 319 casts a duty on the court to ensure that any person who appears to have committed the crime must be brought before the court and tried along with other accused. In the present case, application under Section 319 was made by respondent number 2 during pendency of trial. The order passed in revision by High Court cannot be rendered ineffective merely on procedural grounds, especially when it involves substantive rights of the parties and seeks to cure a patent illegality. However, it is opposite to clarify in the same breath that although the law allows for travelling back of revisional order of High Court, yet it is far from ideal to do so after the passage of substantial period of time, in this case 10 years after the conclusion of trial. The correct approach to be adopted in such cases is that High Court should direct trial court to states proceedings till revision proceedings in respect of section 319 are disposed of. At the same time, High Court must also expedite the revision proceedings so as to ensure unreasonable delay is not caused in the conclusion of trial. In the facts of present case, application 319 was rejected by trial court, but revision against such rejection was entertained by High Court without allegedly putting the proposed accused to notice. Upon careful perusal of decision in Yashodhan Singh, court said that we are of the view that right of hearing is not available to proposed accused only in first instance, that is, only at the stage when the application is being heard for the first time. Court recorded in its findings in the case that High Court in exercise of revisional jurisdiction was justified in setting aside order passed by trial court rejecting second application by respondent 2 under section 319 of CRPC, as the same was found to be passed contrary to settled position of law, suffering from patent illegality, thus leading to serious miscarriage of justice. Once a superior court deems fit to interfere with order passed by subordinate court, then any rectification to such order passed in exercise of revisional powers under section 401 read with section 397 of CRPC must be treated on the same footing as rectifications made by appellate court, and as a result would relate back to the time the original order was passed. By virtue of relating back of the order passed by High Court in revision petition, summoning order passed by trial court in compliance with order of High Court would also relate back to initial order rejecting second application under section 319 and therefore could be said to have been passed before conclusion of trial. Unlike cases where an application under 319 is being decided in first instance by trial court, conclusion of trial will have no bearing on adjudication of application under section 319 in terms of directions of High Court passed in exercise of revisional jurisdiction. The legal effect of the order passed by High Court relating back to original order of trial court is that trial court would not be rendered functus officio for the purpose of considering application under section 319 after conclusion of trial. Court said we say so because the trial court in considering application under 319 after conclusion of trial merely gave effect to divisional order directing it to consider application afresh, which it had originally rejected. Section 319 does not contemplate that a summoned person must be given opportunity of being heard before being added as an accused to face the trial. A right of hearing would accrue only to a person who is already discharged in the very same proceeding prior to the commencement of the trial. This is different from holding that a person who has been summoned as per section 319 CRPC has a right of being heard in accordance with principles of natural justice before being added as an accused to be tried along with other accused. However, after rejection of application under 319, a right inures in favor of proposed accused. Thereafter, if in exercise of revisional jurisdiction, High Court is to pass an order which is prejudicial to benefit which had already inured in favor of proposed accused, then the High Court is obligated in law to provide an opportunity of hearing to proposed accused. This is also mandate as contained in subsection 2 of section 401 of CRPC. Court referred to the Latin maxim actus curiae neminem gravibit. An act of court shall prejudice no man. As a secutor, no man should suffer because of the fault of court or delay in the procedure.